And just to do a little bit of review, we looked at what is considered false imprisonment. We looked at definition of false arrest or unlawful arrest and imprisonment. We looked at the length of time requirement regarding that. Also, remedy and damage for unlawful arrest and imprisonment. Also, malicious prosecution. And we are in the section where Weisman is giving some of his court paperwork, a sample of his court paperwork going through his case. And we're on the section, if you guys are following along, I don't know if this will be if it'll line up if you're looking at a PDF on your computer. It's page 15, where Charles Weisman goes through a memorandum of law on arrest without warrant. So he's going through, we're in the section called Arguments and Statements of Law. So I'll just start reading from there, and we'll see where we end up. So it says the defendant claims that his arrest of the plaintiff without a warrant for violation of 2 traffic laws was lawful. They always think that what they do, the policy enforcers, are lawful. Defendant claims that he is authorized by statute to make arrests for any violation of laws of the state, whether they are misdemeanor or a felony, when committed in his presence. The facts of this case lead to the conclusion of law that the defendant, which is Weisman, did not have any lawful authority. It was the policy enforcer, did not have any lawful authority to arrest the plaintiff, which is Weisman. Defendant had no warrant for the arrest of the plaintiff, and he alleges that he only saw plaintiff commit a misdemeanor. Example, a traffic violation. There is no claim of a felony committed or of a breach of peace committed. At common law and under the provisions of due process of law, such an arrest without a warrant cannot be made. Let me read that again. At common law and under the provisions of due process of law, such an arrest without a warrant cannot be made, since the arrest deprived the plaintiff of his liberty by an act not pursuant to due process of law. The arrest is unlawful. Due process is not determined by the legislature. That's interesting to know. It is manifest it was not left to the legislative power to enact any process which might be devised. The due process article is a restraint on the legislative as well as on the executive and judicial powers of government, and cannot be so construed as to leave Congress free to make any process due process of law by its mere will. That is from a court case. Hopefully you guys have a copy of this. I'm not going to read the cite, but anyway, that was from a court case. The Constitution of Minnesota declares that no person shall be deprived of life, liberty, or property without due process of law. Now, it should be something similar in all the states regarding life, liberty, and property of a man or woman. That can't be taken away, that the power resides in the people. I'm going to read a couple excerpts from the one in the state I live. So it says, most likely in the Constitution will be in the article. But it's interesting in the Commonwealth of Pennsylvania Constitution, the preamble says, "We, the people of the Commonwealth of Pennsylvania, grateful to Almighty God for the blessings of civil and religious liberty, and humbly invoking His guidance, do ordain and establish this Constitution." So it's kind of cool that they recognize and give attestation to Almighty God. So Article 1, Declaration of Rights, that the general, great, and essential principles of liberty and free government may be recognized and unalterably established. We declare that, Section 1, inherent rights of mankind, all men are born equally free and independent, and have certain inherent and indefeasible rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property and reputation, and of pursuing their own happiness. Now, it goes into some other sections which go along that lines. But like I said, every state constitution should have something along those lines. Back to the treatise. The words due process do not mean anything which the legislature may see fit to declare to be due process of law. That was a cite from a court case as well. Due process was intended to preserve established fundamental rights by requiring that they cannot be deprived except by the established modes of law as existing under the common law. This guarantee that government shall follow a specified and pre-existing rule of conduct, process, or procedure is in itself a right the citizen held the common law that was claimed by the colonists in early America. Thus, it is clear that the common law is the foundation of that which is designated as due process of law. That's referring to, I don't know what 6 RCL is. Maybe it's revised constitutional law, but that's under section 435. Anyway, the Constitution guarantees these pre-existing rights and procedures in the due process provision. Now, here's another court case cite. What is due process of law may be ascertained by an examination of those settled usages and modes of proceedings existing in the common and statute law of England before the emigration of our ancestors. The expressions due process of law and law of the land have the same meaning. The law intended by the Constitution is the common law that had come down to us from our, hit the wrong button here, had come down to us from our forefathers as it existed and was understood and administered when that instrument was framed and adopted. In interpreting what due process of law is, it has been held that none of our liberties are to be taken away except in accordance with established principles. That's another court case cite. Thus, the mode of arrest by which one can be deprived of his liberty is to be determined by the pre-existing common law principles and modes of procedure. A properly constituted warrant of arrest is a process at common law by which persons could lawfully be deprived of their liberty. The common law on arrest without warrant recognized only certain specific and well-defined cases whereby a citizen could be deprived of his liberty. This cannot be abrogated or changed by the legislature. The common law drew a distinction between an arrest for misdemeanors, such as that which the defendant arrested the plaintiff upon, and arrest for felonies. When a felony was committed, an arrest could be made without a warrant, but no arrest could be made for a misdemeanor without a warrant unless it constituted a breach of the peace. The misdemeanor traffic violation was not a breach of the peace, thus a defendant needed a warrant to make an arrest for such offenses. So what is the trifecta of law or due process in this situation that we've been going over? Can anybody tell me? There's only 3 reasons why a policy enforcer could even interact with a man or woman. I call it the trifecta. The trifecta hammer.
One of them is if there's felony actively being committed, I think.
Right. Good.
If they have a warrant, I think.
Right. You want to clarify that with lawful warrant. Because I know a lot of times the warrants that they use are not lawful.
Mm-hmm.
And the last?
There's breach of the peace.
Breach of the peace. So he has to be witnessing or have evidence that you are engaging in one of those 2 things, or that he has a lawful warrant. Again,
They must not realize. They must not realize they could grab those people and take them away in Seattle and Portland and all the other places where they're having all the problems.
Right. Breach of the peace, they could take them without a warrant, right? And it's good that, you know, just remembering these 3 things are foundational, because that's pretty much the only way they can interact with us. Nothing else matters. It doesn't. You don't have to even. Obviously, statutes are off the table, but even regarding some law, doesn't really need to be on the table. If we're able to just focus in on those three things, we're in a good position to retain our liberty, hopefully. All right, does anybody have any questions or comments up at this point? If not, I'll just continue reading. Okay. In determining the law surrounding arrest, the Supreme Court of South Carolina, in the case of State versus Byrd, affirmed a prior decision of the court holding that, at common law, as a general rule, an arrest cannot be made without warrant for an offense less than a felony, except for a breach of the peace. The fact that the defendant believed that the plaintiff committed a misdemeanor and had charged him with a violation of the traffic law did not authorize him to arrest the plaintiff. In a New York case, the state Supreme Court held that a city alderman or justice of the peace could not, at common law, arrest or cause an arrest for a misdemeanor not amounting to a breach of the peace without warrant, though happening in his presence. The Supreme Court, in the case of Butolph versus Blust, stated, at common law, an arrest cannot be made of a person charged with a misdemeanor, except on warrant of a magistrate, unless it involved a breach of the peace, in which case the offender might be arrested by any person present at its commission. So essentially, there doesn't even have to, it could be a citizen's arrest as well. Doesn't necessarily need to involve a policy enforcer. In the very well-reasoned and authoritative case of Ex parte Rhodes, the Supreme Court of Alabama related the due process provision to the act of arrests. It asserted that any seizure or arrest of a citizen is not reasonable or due process, merely because the legislature has attempted to authorize it. These phrases are limitations upon the power of the legislature, as well as upon that of the other departments of government or their officers. In determining what was due process regarding arrests, the court stated, must not be forgotten that there can be no arrest without due process of law. An arrest without warrant has never been lawful, except in those cases where the public security requires it. And this has only been recognized in felony and in breaches of the peace committed in the presence of the officer. The Alabama Supreme Court in the Rhodes case went on to say that the phrase due process must be determined by what it meant at the common law and when the Constitution was adopted. The court then cites the case of Tillman versus Beard and stating, officers are justified in arresting without warrant only in cases of felony and breaches of the peace. This is elementary. It is needless to cite authorities. At one time in the history of American law and jurisprudence, the concept that no one could be arrested for a misdemeanor except with a proper warrant was so basic and elementary that it was not necessary to give any authorities to prove it. Yet this basic concept was found to be too restrictive to the ever-growing oppressive government that has gained power in this country. Thus, in order for it to control the liberty of citizens and to enforce its oppressive laws, the corrupt de facto government has gradually undermined a very basic principle of constitutional law. Oh, really? That's obvious. In the Pinkerton case, Supra, it was held that a policy enforcer could not arrest a woman without a warrant upon mere suspicion that she was upon the street for the purpose of prostitution, even under provisions of the city ordinance allowing such arrests. The fact that she had a reputation of being a streetwalker and that the officer knew of her reputation and believed she was plying her vocation as such, plus the fact she did not give her name to the officer, stating it was none of his business, and that she dared the officer to arrest her, did not give the officer grounds to arrest her. The court said, if persons can be restrained of their liberty and assaulted and imprisoned under such circumstances without complaint or warrant, then there is no limit to the power of a policy enforcer. Any law which would place the keeping and safe conduct of another in the hands of even a conservator of the peace, unless for some breach of the peace committed in his presence, or upon suspicion of felony, would be most oppressive and unjust and destroy all the rights which our Constitution guarantees. These are rights which existed long before our Constitution, and we have taken just pride in their maintenance, making them a part of the fundamental law of the land. So under the topic of arrest is found in Volume 2 of Ruling Case Law. We find the heading Constitutional Requirements as to warrants, wherein it states, the fundamental constitutional guarantees of personal liberty protect private individuals in the right of enjoyment of personal freedom without unlawful restraint, and it is universally recognized that no one may be arrested except by due process of law. Here again we find that this principle of arrest only by due process of law was once universally recognized, yet the defendant has ignored such process in his arrest of the plaintiff. The law regarding warrantless arrest was also declared by the Supreme Court of Wisconsin in the case of Radloff versus National Food Stores, Inc. as follows. In Stinchen versus Rundle, this court established the principle that an arrest without warrant has never been lawful, except in those cases where the public security requires it. And this has only been recognized in felony and in breaches of the peace committed in the presence of the officer. This rule was reaffirmed in another court case. In One American Law Reports, annotated, says the Radloff case involved a shoplifter who was stopped and arrested by store employees for taking 2 cartons of cigarettes. The state Supreme Court said that the employees had the right to stop the shoplifter and recover the goods he had stolen from their employer, and were not negligent per se in so doing. However, since the taking of the cigarettes constituted a misdemeanor, the store employees had no right to arrest the shoplifter when they had no warrant to arrest. That's interesting. In the Gunderson case, the court explained that arrests without warrants were allowed at common law only when the ends of justice would be defeated without it, and it must be confined to cases of strict public necessity. Well, that's kind of ambiguous. Where a person was arrested without warrant and charged with public drunkenness, which resulted in charges of resisting arrest, it was held by the Supreme Court of North Carolina that the arrest was illegal as the state failed to make a prima facie case by showing that the defendant's conduct at the time of arrest amounted to either an actual or threatened breach of the peace. The court said, it is manifest that mere drunkenness, unaccompanied by language or conduct which creates public disorder, amounting to a breach of the peace, will not justify arrest without a warrant, and that not every misdemeanor is a breach of the peace. In a very well-reasoned decision on the subject of arrest, the court held the following. This is a little lengthy here. It has always been the general rule of the common law that ordinarily an arrest should not be made without warrant, and that subject to well-defined exceptions, an arrest without warrant is deemed unlawful. This foundation principle of the common law, designed and intended to protect the people against the abuses of arbitrary arrests, is of ancient origin. It derives from assurances of Magna Carta and harmonizes with the spirit of our constitutional precepts that the people should be secure in their persons. Nevertheless, to this general rule that no man should be taken into custody of the law without the sanction of a warrant or other judicial authority, the processes of the early English common law and deference to the requirements of public security worked out a number of exceptions. These exceptions related in the main to cases involving felonies and suspected felonies and to breaches of the peace. So Mr. Weisman's really hammering home this trifecta hammer. The overall opinion of the court stressed the principle of the common law as controlling an arrest, thus characterizing as erroneous the view that any offense in the presence of an officer is arrestable without warrant. In Texas, it was held that an arrest without a warrant for selling in the officer's presence a railroad ticket in violation of a city ordinance prohibiting the selling of such tickets was unlawful, as the offense charged was not a felony nor an offense against the public peace. seems like a lot of things hang on these two issues. Sheriffs, constables, and other officers under the executive branch of government had always been recognized as having authority to arrest for felonies committed and for misdemeanors amounting to a breach of peace, but this is the extent of their power to arrest without a warrant. And this constitutional principle is well grounded in ancient common law safeguards of individual liberty. Here's another court case site. In England, under the common law, sheriffs, justices of the peace, coroners, constables, and watchmen were entrusted with special powers as conservators of the peace, with authority to arrest felons and persons reasonably suspected of being felons. Conservators of the peace also had the authority to make arrests without warrants in case of a misdemeanor which involved a breach of the peace committed in the presence of the officer making the arrest. So I have a question. So if there's a breach of the peace, it's committed, but there is no presence of an officer, how would that be handled? Let's say he's called in after the fact. That'd be interesting. Anybody want to weigh in on that? No takers, huh? Okay, we'll continue on. It has been held that constitutional provisions of rights are to be interpreted according to the common and statute law of England prior to the emigration of our ancestors, and by the law established here before the Constitution was adopted. Under the common law, the powers of state agents were limited, and the requirements for an arrest warrant was strictly enforced. That's in United States versus Tarlowski. This procedure for arrest is part of the due process of law. Provision of the Constitution will protect citizens from the arbitrary infringement of their right to personal liberty. Thus, any specific authority for arrests must be based upon the common law procedures that allowed a deprivation of one's liberty. This was so held by the Supreme Court of Michigan as follows. It has already been decided that no arrest can be lawfully made without warrant except in the cases existing at common law before our Constitution was adopted. Since liberty cannot be deprived except by the law of the land or due process of law, no statute or ordinance can constitutionally be enacted which allows arrest without a warrant for any purpose the legislature decides. Due process is a limitation upon the legislature, and thus a legislative statute cannot be the due process by which one can be deprived of his liberty by arrests. This is also good to keep in mind because policy enforcers, I've heard people ask them what their probable cause is for stopping them or the reasonable suspicion. And for those of us who have experienced this, the policy enforcer usually brings up any old reason he wants. Either it's statutory or he just makes it up. So this is really clear and to the point of proper due process and even probable cause, at least in my mind. Anybody have any thoughts on that? That's why I think it's important to make it a point to ask these policy enforcers if they've witnessed, us committing a felony or a breach of the peace or have a lawful warrant for even interacting with us. Probable cause, at this point, I wouldn't even bring that up, or the issue of reasonable suspicion, because in their minds that's too ambiguous and quite open for any application. Let's see, where was I? In a legal article titled Arrest with and Without a Warrant, written in the University of Pennsylvania Law Review, numerous authorities were cited in support of the following proposition. Now, it's interesting because I'm in Pennsylvania, or the state commonly known as Pennsylvania. I think I shared a little bit of a resource last week about how in Pennsylvania they were dealing with the very issue of false arrests and false imprisonments. So anyway, this article goes on to say, it is usually said that not even a peace officer is privileged to make an arrest without a warrant for a misdemeanor, which does not amount to a breach of the peace. So if someone commits a so-called misdemeanor, but it's not a breach of the peace, cannot make the arrest. They have no warrant. And there are many cases which expressly deny the privilege to arrest for such a misdemeanor. In the annotation of the American Law Reports, Volume 1, page 585, for you law researchers out there, has found a legal study entitled Constitutionality of Statute or Ordinance Authorizing an Arrest Without a Warrant, in which the following is stated. It has been stated that in cases less than a felony, an arrest can only be made without a warrant. Does anybody know what the answer is? Where there was a breach of the peace in the presence of the person arresting. The limits to the power of arrest by a constable without process was well defined at common law. To prevent the escape of a felon, he had authority to arrest anyone whom he reasonably suspected to have been engaged in the perpetration of a felony. To prevent breaches of the peace, he had the right to arrest any person who was engaged in or in his presence threatened to engage in an affray or other breach of the peace. Beyond this, the law did not allow him to exercise the function of determining whether there was sufficient case of the violation of a law to justify an arrest. After this excerpt, the law report stated that the foregoing statement from a case called Newark versus Murphy is in accord with the weight of American opinion. Those cases which seem to deviate from this proposition are those which have upheld arrests for certain acts that were unlawful at common law, such as streetwalkers. In Tiedemann's Treatise on the Limitations of Police Power is found the requirements for a lawful arrest and exceptions to a warrantless arrest. Section 33. What constitutes a lawful arrest? As a general proposition, no one can make a lawful arrest for a crime except an officer who has a warrant issued by a court or magistrate having the competent authority. Section 33A. Arrest without a warrant. Although it is the general rule of law that there can be no arrest without a warrant of the nature just described, yet there are cases in which the requirement of a warrant would so obstruct the effectual enforcement of the laws that the ends of justice would be defeated. For public reasons, therefore, in a few cases, the personal security of the citizen is subjected to the further liability of being arrested by a policy enforcer or private individual without warrant. But the right thus to arrest without a warrant must be confined to the cases of strict public necessity. The cases are few in number and may be stated as follows. Number one, when a felony is being committed, an arrest may be made without a warrant to prevent any further violation of the law. Number two, when the felony has been committed and the officer or private individual is justified by the facts within his knowledge in believing that the person arrested has committed the crime. Number three, what do you think it is? All breaches of the peace, in assaults and batteries, affrays, riots, etc., for the purpose of restoring order immediately. The rule of the common law that a peace officer or a private citizen may arrest a felon without a warrant or on view a breach of the peace has never been extended to any and all misdemeanors. While there have been some erroneous decisions that have recognized statutes authorizing arrests for misdemeanors that do not constitute a breach of the peace, none are based on the meaning of due process of law. Thus, arrests are not lawful where only a misdemeanor occurs, unless it is of the nature of a... Anybody want to answer that? If there is a misdemeanor that is committed, someone can only be arrested under what condition?
If it's a breach of the peace?
Breach of the peace. There you go. Like I said, Weisman's really hammering this home. Here's a court case cite. At the common law, an officer had no authority to make an arrest for a misdemeanor, though committed in his presence, unless it involved a breach of the peace. The right of personal liberty is a very high prerogative right, and to deprive one of that right without due process of law, we must find specific authority for doing so. It cannot be left to inference or some strained construction of statute and ordinance. That is pretty good. The specific authority for arrest is grounded in the ancient settled maxims of law. Maxims are established principles which cannot be argued, which no statute can abrogate without violating the due process of law provision of the Constitution. Thus, a warrant must be obtained for a misdemeanor that is not a breach of the peace. The Supreme Court of Minnesota has stated on several occasions that even in the case of a felony, an arrest and search should not be made without a warrant unless there's a compelling necessity to do so. The Supreme Court of Rhode Island, in declaring the requirements of common law for an arrest, stated, quote, that law permitted an officer to arrest without a warrant on reasonable suspicion based on his knowledge that a felony has been committed, in all other cases except in the cases of a misdemeanor amounting to a breach of the peace committed in his presence, an officer had no authority at common law to arrest without a warrant. Closed quote. In American jurisprudence, ding, 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 pop quiz. Can anybody tell me the meaning of jurisprudence? See if you guys are on your toes. Jurisprudence is a compound word. Juris meaning law, prudence meaning knowledge or science, so it's science of the law, or it's law of good judgment or wisdom. So in American Jurisprudence, in the second edition, in Volume 5, under the subject of arrest, sections 26 and 28, pages 716 and 718. Did you guys get all that? Do you need me to repeat it if you're writing it down? It states, at common law, a peace officer cannot arrest without warrant for a misdemeanor, although committed in his presence, unless a breach of peace is involved. At common law, the right to arrest for a misdemeanor committed in the presence of the officer is limited to those offenses which amount to a breach of the peace. The basis for the rule is that arrest without a warrant is permitted in cases less than felony, not for the apprehension of the offender, but only for the immediate preservation of the public peace. And accordingly, when the public peace is not menaced, a warrant is necessary. In Corpus Juris Secundum, the body of the second giving of the law, volume 6-8, under the subject of arrest and under the heading of arrest or detention without warrant, it is written, at common law, however, it has always been the rule that, except in cases where the public security has demanded it, arrest without a warrant is deemed to be unlawful. Due process of law, which declares that no citizen shall be deprived of any of his rights of life, liberty, or property unless by the law of the land or the judgment of his peers. Now, does anybody remember what Weisman mentioned, what is equated to the law of the land? It's due process of law. So that, what he's saying, that's synonymous with the law of the land. Let's see. The law of land or the judgment of his peers is the controlling factor in the matter of the arrest made by the defendant. An arrest is a deprivation of one's liberty, and the due process that must be followed is an arrest. In an arrest is that process which existed at common law. To prevent the exercise of arbitrary power at the discretion of government, it was deemed wise to secure the principles already settled in the common law upon this vital point of civil liberty in written constitutions. Now, tell me if you agree or disagree. I think we went over this, but it's good to do review every once in a while. The moment a policy enforcer puts his lights on, are you under arrest? Or is it when you are brought to a jail and booked?
I think they determine you to be under arrest, but actually he's creating a disturbance of the peace.
Okay, but it has to be determined the moment because when he puts his lights on, he's interfering with a man's or woman's liberty of free movement. In
Exactly.
my mind,
but he's creating a disturbance of the peace.
Yeah.
By him putting those lights on.
So we are under arrest the moment he puts his lights on.
Yes.
Yeah, that needs to be, I think, understood because the common belief of that is, like I said, most of us know, and before I read this treatise, I didn't realize it, is when you're taken to, when you're incarcerated. That's when you are under arrest. But according to what we're reading here, the moment they interfere with your freedom of movement, we're under arrest. And just like, how'd you say it, David? They are. How'd you put
they're
it?
They're guilty of disturbing the peace.
Yeah, disturbing the peace.
When they turn on those lights, we could arrest them for disturbing the peace.
Right. They're actually breaching the peace. Yeah. Right.
Yeah.
What's good for the goose is good for the gander. I don't know if that could necessarily be applied here.
It's money in your pocket.
Yeah.
It's money in your pocket because they're operating under their own individual unlimited personal liability, open to a tort claim.
Yep, and this is what this study's all about, and how we could keep these people accountable and hopefully get remedy and damages. Anyway, anybody else? Hey, Brent.
Hey, how's it going?
Going good. Nice of you to join us. I see someone else on the call. I don't recognize the number. Here he gives an example where a Chicago policeman arrested a man for vagrancy. The officer was found guilty by a jury of false imprisonment. The Supreme Court, the officer was found guilty by a jury of false imprisonment. The Supreme Court of Illinois upheld the conviction of the policeman and declared the rule of law regarding arrest without warrants. Blackstone says the constable has great original and inherent authority with regard to arrests. He may, without a warrant, arrest anyone for a breach of the peace committed in his view and carry him before a justice of the peace. In a case of felony actually committed or dangerous wounding whereby felony is likely to ensue, he may, upon probable suspicion, arrest the felon, and for that purpose is authorized, as upon a justice's warrant, to break open doors and even to kill the felon if he cannot otherwise be taken. Oh, serious. In all other cases, however, the authorities are uniform. A constable or policeman has no authority to make an arrest without a warrant. In a case for false imprisonment, the Supreme Court of Maine examined the law regarding arrests and held the principles which by the common law regulate the right to arrest or cause an arrest without warrant have been long settled both in this country and England, and by these principles the rights of these parties must be determined. After citing numerous cases involving the authority to arrest, the court stated, in many of these cases it seems to have been held that the authority of an officer to arrest for misdemeanor without a warrant is limited to breaches of the peace, or a phrase committed in his presence. A phrase. Does anybody know what a fray is?
That's what Antifa and Black Lives Matter people do.
Yeah, it's an instance of fighting in a public place, that disturbs the peace. It's a good example there, David. Thanks. In a case involving a state liquor prohibition law, a man, while walking down along a public street, was accosted by a policy enforcer and asked if he had any liquor on his person. He replied that he did. Thereupon, the officer searched him and found a pint bottle of liquor in his inside coat pocket. He was then taken to the police station. The State Supreme Court of Wisconsin said that when the police officer stopped the man, he was illegally arrested and was illegally searched, as he had no warrant to do either. The court said that it is a serious thing to arrest a citizen, and it is a more serious thing to search his person, and it must be done in conformity to the laws of the land, which is due process regarding the law on arrests. It held, quote, at common law, arrests for misdemeanors were not here it is again, were not permissible without a warrant except for acts committed in the presence of the officer causing a breach of the peace, quote unquote. Seeing a pattern here, huh? Thus, in order that the citizen's sacred right of liberty be secure and preserved, it has always been fundamental law that arrests without warrant were not deemed lawful, with only a few well-established exceptions of felonies and breaches of the peace. The liberty of citizens would never be safe if such principles could be determined and thus abrogated by statute. Therefore, these principles surrounding arrests are regarded as fundamental law under our American system of government as held by the Supreme Court of Michigan. Quote, under our system, we have repeatedly decided, in accordance with constitutional principles as construed everywhere, that no arrest can be made without warrant except in cases of felony or in cases of breaches of the peace committed in the presence of the arresting officer. This exception in cases of breaches of the peace has only been allowed by reason of the immediate danger to the safety of the community against crimes of violence. Close quote. We're going to go just a little bit more here because it's quite extensive. Then we'll open it up for discussion. In the Yerkes case, it was held that the playing of baseball on Sunday did not necessarily involve a breach of peace justifying an arrest, though it may cause a breach of peace. The court said that before a summary arrest can be made for a breach of the peace, not only must overt acts be committed in the presence of the officer, but they must be violent and dangerous acts of some sort. In the Robinson case, the court held that a liquor law ordinance which allowed arrests without process was unconstitutional because it was not pursuant to due process of the law. So what's equal to due process of the law? What's synonymous to due process of law? The law of the land. Where a man was arrested for public drunkenness, the question arose whether this was an offense for which one could be arrested without a warrant. The Supreme Court of Appeals of Virginia declared the law on arrests, quote, the common law relating to arrest is the law on that subject in Virginia. At common law, a peace officer may arrest without a warrant for what? A breach of the peace committed in his presence, but for no other misdemeanor. Close quote. The common law on arrest is the same in every state, as due process of law has the same meaning throughout America. So actually, David, what you mentioned earlier, it could be, there's a trifecta of synonyms here. The common law, due process of law, the law of the land. The security of the citizen's liberty in this country is to be more highly regarded than it was in England under the common law. To say it is less regarded is to make a mockery of the revolution. Okay, let's see where we want to go here. Let's do one more section and then we'll end it for tonight and then open it for conversation. In a New Jersey case, a man was arrested by 2 city policemen on orders of their superior to do so, alleging that he was guilty of disorderly conduct and was taken to a police station held overnight. This was done without any charge or complaint made against the man and without any warrant. The only authority for the arrest was that the officers were told to do so. In a suit for false imprisonment, it was held by the Supreme Court of New Jersey that the arrest was without authority and gave the following opinion, quote, "The legal principle underlying this case and the one to be applied to the facts is firmly embodied in the roots of the common law, which has been handed down to us from early times unimpaired in its full vigor for the protection of personal liberty against illegal arrests. The liberty of the person is too important a matter to the state to be interfered with without the safeguards with which the law guards such invasions. This court has said the limits to the power of arrest by a constable without process was well defined in common law. The regard for liberty of the person was so great that the common law did not confer upon a mere conservator of the peace the power to touch the person of the subject of his own volition, except in those cases when the interests of the public absolutely demanded it." So we'll just stop there for tonight, and as always, open it up for questions or comments or anything someone wants to share.
I have a story and a question.
Great.
I'm thinking back to an episode where Mom and I were in the car a couple years ago or so, more than that, I think, and we got pulled over and she got arrested for whatever reason they gave. I don't remember exactly, but she had an expired license. And then as I was standing outside near the car, they told me I needed to leave because if I didn't, they would arrest me or charge me with either breach of the peace or disturbing the peace. I can't remember which, and I was wondering if there's any difference, but I just thought of that episode, and I'm like, oh, I don't know if they had a real claim for that because I was just standing there. I wasn't violent, I assure you.
Yeah. They do things that either they're aware that they're breaking the law or they are truly ignorant. And yeah, I mean, it's not, I don't know, how would he clarify that or justify you breaching the peace? Or were you on a highway, or were you in a populated area, or where were you at?
It was Airport Way. I think we were on an access road. Let's see, it was right in front of Alaska Land. Well, you wouldn't have that frame of reference, would you? So maybe Mom remembers what was happening exactly, but all I remember is I had to I think we were on an access
what'd you
road
do?
that wasn't really traveled.
Did you take the car and leave, or
no?
Would you just have to walk off
left.
into the night or something?
Yeah, basically I just had to
wow.
Get across the road and climb over a concrete thing. So I don't remember the details too much, but I was just standing there. I wasn't.
So they basically just told you to be there. They just told you to
basically.
Get out of here.
Yeah, and I think they were just, seeing if intimidation would work, and I didn't know any better. It shocked me. I was like, you're going to what me for what?
Right.
So I knew that was incorrect. They were misrepresenting something, but I didn't have
they always
any
do.
information. Yeah.
So how long ago was this?
I wish I remember. It was maybe 3 or 4 years ago, if not 5.
So how would you handle it if what you know now back then, just hypothetically,
sure.
how would you handle it?
Yeah. The situation being so completely different. Honestly, actually, I'd probably just do the same thing. I don't know. I could ask, what's the definition of breaching the peace, but I don't know. But if I were stopped, I would definitely, I have a passport now, so what I did when I was stopped before is I handed them a passport, and that was the end of it. But I'm not sure what I would do. I'm pretty, I'd probably just walk away anyway. But now I know that they were incorrect.
Yeah. Yeah, and you can pursue, apparently you could litigate against them. And
yeah, I could follow up. I'd probably do that.
Maria, was that the was that the episode that you shared with us that you were brought down to the station and you asked to be brought before a magistrate right away and they ignored you? Was that the incident?
Yeah, that was it. This is Bill. She had to take another call.
Oh, okay.
But
nothing came from that, I guess. I guess that's just a closed case. Nothing else happened from there.
Oh no, we went to court on that for like 2 years. I think we ended up in court like 16 or 18 different times.
Oh, okay, yeah, that's right.
It's like, yeah, it was really frustrating for them. Oh well.
Yeah, oh well. It's too bad. I'm surprised it dragged out that long. That's crazy. But I mean, that's done with. She doesn't have to deal with that issue any longer, correct?
I don't think so. It's like they told her that she had to pay a $200 fine, and that never got paid. So I don't know what they're going to try to do with that. I'm sure since she stipulated, well, the cop, he gets paid, and the judge, he gets paid, and the prosecuting attorney, he gets paid. I'm the only one that's not getting paid. I'm going to get paid. So, I think it was something like $1,800 per appearance, and it worked into a considerable pile of money that they didn't seem like they wanted to pay. So if they try to get her to pay the $200, she'll just send them a bill for what they owe her, minus $200.
Yeah. That's the other thing is learning how to collect on these things. I know some people have gone to a small claims court, or they make a claim to whatever the insurance carrier is.
Yeah. It's all a learning process. We're lots better off now for the knowledge than we were before. So, even if it does just really frost you at the time.
Yeah, right. Maybe Dave has some experiences of getting paid from these people for being inconvenienced. Dave, do you have any experiences with that?
No. The only time I did a little 3-page administrative process. I was stopped at midnight coming back from a business meeting in a little small town here in Kansas by the night deputy. The little town was only maybe 2,500 people, but it had 4 lanes going through the main street, and then it went back to 2 as you were going out of town, and then he stopped me and charged me with driving on the shoulder of the road.
I just crack up because the guy's got nothing else to do. I mean, late at night, he's like, I got to do something.
Right. Well, I had a Continental Rangers band. I'm president of Kansas Continental Rangers, which it is basically defunct anymore. But anyway, he stopped me, and I asked him, by what authority he was doing what he was doing. He said, well, my badge is my authority. I said, hell, I got a badge. He said, well, can you arrest people? I said, sure I can. And I told him, I says, if you put my name on that ticket, I says, you'll have repercussions from it. He said, well, this is just says you'll show up in court. I said, okay. So he gave me the ticket. I drove off, didn't go to court or anything. I got a letter from him about 3 weeks later. They were going to up my fine from $25 to $150 or something. And I wrote a 3-page administrative procedure. And it was really nice because when they sent me the threatening letter, I had the the officer's name on it, but on the city's letterhead, they had the chief of police, the mayor,
Oh, really?
the city prosecutor. So I sent each one of them a copy and told them I was going to charge them $4,000 each for my time and effort if they didn't answer my process. Never heard another word from them. So I was reading it the other day. That's been, almost 20 years ago.
They drop you like a hot potato.
Like, I don't have any trouble with them anymore because I have a book that I carry in my car, and I've copyrighted and trademarked my name on the affidavit of copyright. It also has a little thing down there. This is a 15 U.S. SEC document, not a point of law. Well, what that does, that turns that affidavit into a security governed by the Securities and Exchange Commission, and if they violate it, they automatically, by law, become a lien debtor. Now, I haven't been stopped since I thought of this. The last 3 times I stopped, they run my thing, and they said, drive carefully, have a nice day, and they leave faster than I leave. I don't know what's on my thing. I know I'm listed as a potential terrorist.
Sovereign citizen.
Well, more than that, but anyway.
Do you have a I'm sorry, go ahead.
No, my driver's license expired in 2004. I got a notice from the state of Kansas in 2009 that they were, how'd they put it? They were suspending my expired license.
They just grasp at straws. And your car's not registered with the state, I gather.
One of them isn't. I got some others that are. My wife is. I spent some time in jail, and she doesn't want me to go back, and I don't either particularly, so sometimes it's easier just pay the blood money and not do anything, although I'm working on getting my private tags. I'm not sure. Well, with this bunch of clowns that are going to be running the government for a while here now, I don't know whether you're safe or not. Because if you do anything wrong, they'll classify you as a terrorist, probably. But with my little copyright and trademark, if one would stop me, I would ask him. I'd ask him how he was doing. I hope he's having a nice day, and that. And I'd ask him, does this have to do with traffic? And he's going to look at me, yeah. I said, oh, you were trying to engage me in a commercial contract? Because if you look under Black's Law Dictionary and you look at traffic, one word synonym over commerce.
Yeah.
So under commerce, you got 72 hours to decline that contract. And then if they want to come after you more, they're going to have to write your name again. Each time they write their name, I'm going to put 2 or 3 zeros on the end of whatever they think is worth to them, what they're worth to me.
Good stuff.
Send them a bill and see what happens, You want me to pay you $250? I'm only going to charge you $25,000, so subtract that, you owe me $24,750.
Take them to small claims court.
Yep.
Chris, what's going on with you, brother?
You know me, moving and shaking, man. Coming up with counters. Counterpunch.
Have you gotten any other paperwork from the de facto den of thieves?
Oh no. I think I'm pretty safe from those guys for quite a while. Really, I think they're probably licking their wounds and figuring out how they can dispose of me. They probably don't want to see me no more.
Yeah, right. Yeah.
But kind of working on some stuff right now, the affidavit rebuttal and some other things. There's a Crow 777 episode I would like to recommend to you guys. I don't know if Maria had forwarded it to anybody, but it's episode 222, and it kind of lays out the way that things have been working in here without most of us knowing, starting at the county level and then following it through. That these courts, basically, that's one of the main reasons that they're trying to force the attorneys on you, because you don't have any other recourse. But you can move these straight over to federal under 18 U.S.C. 1446, I believe it is, because you can't get a fair trial in the state courts. And
that's true, yeah.
One of the things that we're working on too, I probably don't know if I should completely say it out loud yet, but it has to do with our de jure assembly and grand juries that are assembled in the state of Alaska, and the fact that they can be immediately transferred from federal courts as long as there's a de jure court, and they cannot be challenged by any state or federal court.
Yeah, I'm kind of not educated on all that, the juror assemblies and stuff like that. I haven't gotten around to that. That sounds like interesting stuff. Now, the Crow program that you're talking about, was that a guy by the name of KL that was on there?
No, not him. This guy, he goes by the name of Alphonse. I think he was on maybe episode 113 and then 222.
Okay, and I know Maria sent one of them out.
Yeah.
I ended up listening to one of them. And also, I guess you're aware of the guy goes by the name of KL.
Yep.
Yeah, I got a bunch of stuff from him, I think, last week, where he talks about trusts and goes through the history of why, talking about the reset. You guys heard about that. I think we've all heard about that in the media, and why they're saying it. And it has to do with the debt that was acquired back when this country was starting. They just reset everything and reset the debt.
Yep.
That's the simple part of it. He was talking about, which I'm still learning, taking control of the dead entity, the straw man, being able to take the control of it through setting up a DBA, doing business as, and then you work through trust law. I'm not too sure how that process works. I'm still working through the information. I got to contact him. So Ted said to contact him after I get through all the material, because I want to know the practical steps of that, because maybe there is some value in that. I'm trying to still think, if it's biblical, and if it is right to do, because maybe that's a piece of the puzzle that might be missing, or that we need, is a way to take control of the straw man in a way that we're still be outside of legal land. That's just the way I refer to it. I don't know. Have you looked into that, or has anybody looked into that any further, or at all?
We've kind of discussed it and stuff like that, but that's really that trust stuff. That's really not where most of us want to live, Yeah. And it's all about forming a parallel trust. They've got that trust going on one side. It's always the duality, and then on the other side we have a trust that we form. Like, say, in my particular case, I entrusted my daughter with my wife whenever she moved out, to take care of her and take care of her moral and all that kind of stuff. But whenever she breached that trust, I canceled it. So that's the kind of trust that's the other side of what they're talking about. We form trust and bonds literally by our agreements. And that's the biblical side of trusts. So, it's whether or not we want to dabble in their black magic, or whether or not we actually form these trusts, which are just agreements, on our side. So yeah, that's kind of what we've been coming to.
If I may?
Yeah.
The young people, when they turn 18, they have 180 days to renounce all those fake trusts. Social Security trust, the birth certificate trust, because they weren't able or eligible to contract. And you have to remember, one of the basics of, or fundamentals and maxim of the law, how a thing is done so it can be undone. And another one is you cannot contract against yourself. And one thing we were doing 20 years ago is going through a process called the redemption process, where you do a UCC 1 filing against your straw man, with him the debtor and you the creditor and him the transmitting utility, so you don't have to refile it again. And they have not filed a UCC in the fake trust that they made up. And under the UCC, which they operate under, I think that puts you in a superior position to manage all the problems of the straw man, and it's evidence that you and the straw man are not the same.
Yeah, it's amazing how deep it goes. All right, well, we could, if we don't have any other things to go over, we'll just end the call for tonight and pick it up again next week. I know I wanted to ask you, Chris, going through this treatise, is there anything that you think that you could use or are going to use if you're going to proceed against these people?
Yeah, I think just the key elements right there that you hit on pretty much again tonight, and the one that keeps being reiterated, a breach of first-hand witness, of breach of peace, being the most important. And then, having someone coming forward with a sworn affidavit saying you've done wrong. So yeah. I think those are just the key, realistically, those are the key elements that we need to bring forward. I think all the rest of it is explanatory of the same thing, but in all the different manners.
So you're still contemplating on going on the offensive to keep these people accountable and so on and so forth?
Well, right now I'm with the criminal side of it, this arrest and false imprisonment. It's going to be basically based on what we were doing and some of this information that we've learned, is going to be going forward and doing a dismissal, as well as a counterclaim, as well as the rebuttal of affidavit. So all of this stuff goes on their record in their courts. So these are all leading towards showing the deprivation of rights that happens, that can be moved forward to the federal court, where it's a huge success rate on these. So it's taking these key things, putting it in there, however they want to see it or whatever, but it's basically laying it down, putting the truth there, and showing that they're continually deprivation of rights. I mean, it's top to bottom. We know when they're fraud, but it's like I mentioned a bit ago, that's why they're really trying to force the attorneys on you, because they can't come back with the attorneys against them. But we as individuals can, because once we sign over our rights through the attorneys, you know how that goes.
Yeah, right. It's interesting because as we're going through this, you're actually going through it. So you're sort of a test subject, for lack of a better phrase.
Don't make me feel like a monkey.
Like the guinea pig, not, just to...
Have you accepted their oath of office, Chris? The judge's oath of office? The prosecuting attorney's oath of office?
I did that a couple of years ago through the office of the governor and everybody that's underneath him and all auspices.
Well, it won't work that way. You got to get their oath of office that they signed, and you accept that and create a private binding contract.
Well, the problem is there are no oaths of office for the 4FA district. There are no wet blue ink oaths of office that can be produced. So
then you got a criminal complaint against them for impersonating a public official, and your counterclaim.
Right, but where's the big ones? So that we're kind of trying to focus in on just the big things first, And one of the first is absolutely this arrest and false imprisonment, because that's what's tripping most people up, and it's the most easy to prove. And with that, comes the exposure, and I think we're in a time that, we have good opportunity here to change this system.
So Chris, what do you mean by people are getting tripped up?
Well, like with the arrest and false imprisonments, there was, whenever I was sitting in that cell, there was a handful of the people around that I could speak with that, they were in there on warrants that were, every one of them are fraud. Every one of them for, no matter why they were picked up on a fraudulent warrant. So that's the start. And that's, right there, they're caged because of a fraudulent warrant.
So you mean
goes back to probably a whole lot of fraud.
When you say people are tripped up, you're not saying the people that you spoke with in the jail were not understanding you. It's just they're getting tripped up because of the fraud of the system.
Right, absolutely.
Okay.
And the most obvious section of, the most easiest to catch and prove is this arrest and false imprisonment due to fraudulent warrants.
Right.
And the cover-up thereof. So
right.
That's the very easiest, very simplest part to prove and to take against these people.
Yeah.
Versus all these other things.
The other, I think, important point is very interesting is that the plaintiff doesn't have to prove false arrest and false imprisonment. It's the defendant has to defend against it. So that's different in itself to all other types of claims. That the burden of proof is not on the plaintiff or the claimant.
And that's the part they tried to hide the most.
Yeah.
Because if people knew that the burden of proof was on them, then ball game.
Yeah. It's good stuff. Praise the Lord.
Praise the Lord.
We already won.
Amen, brother. We just got to show up. We just got to stand. That's it.
Yep. Let him do his work.
Yep.
I'll get all the glory.
Amen.
All right. Anybody else before we end for the evening? All right. We'll end the call, and blessings on everybody for the rest of the week. And all of you know about the Bible study on Sunday. If you want to join, go ahead and call in. If not, shame on you. No, I'm only kidding. May the Lord have mercy on your soul. No. All right, y'all. Take care. Have a good rest of the week.
Blessing. Good night.
God bless. Good night.